Your Honor, Robert Ellman with and on behalf of Smith.
Martina Smith.
Thank you.
Your Honor, after having some conversations with Ms. Smith today, I am moving to withdraw as her counsel due to a breakdown in the attorney-client relationship. This also comes at her request.
Is that correct, ma'am?
Yes, I feel that the attorney is not representing me fairly and is taking my life as a game. I just graduated college and
Mr. Ellman?
Yes, sir.
You have got to be kidding me.
Right out of the gate, Judge Simpson is already signaling that this hearing has officially gone off the rails. The moment the defendant starts questioning whether her attorney is taking her seriously, the entire courtroom energy changes. And here's why this matters. Judges hear complaints about lawyers all the time, but this reaction tells you something important immediately. This judge clearly has deep respect for attorney Robert Ellman and is not buying the accusation for even a second. What makes this especially dramatic is the confidence gap happening in real time. The defendant is leaning on the fact that she has a paralegal background and a college degree, while the judge is basically saying, that still does not make you the expert in this courtroom. And honestly, you can feel the tension rising because the judge is taking this personally on behalf of the attorney. This is also a dangerous moment strategically for the defendant. When you accuse appointed counsel of incompetence without solid evidence, you risk alienating the very people controlling your future. Instead of building sympathy, she's creating friction with the bench almost immediately. And let's be real here. When a judge starts defending a lawyer this passionately, you already know this hearing is about to become much bigger than just a routine withdrawal request.
If you hear what I hear, sir, and you wouldn't.
Maybe, so you made that determination with your law degree. Oh, I'm sorry, do you have one?
I have a college degree, paralegal.
Yeah, but you don't have a law degree. I'm going to tell you what, ma'am. This gentleman has been appearing before me since the day he started practice. And if you are coming before me and telling me that in meeting with you as a client, that he does not take you seriously, the jeopardy that you may be facing seriously, or do that, I'm going to be honest with you, I do not believe you at all. That has never been the way that Mr. Ellman has conducted himself in this court. And quite frankly, is one of the finest attorneys Washtenaw County has. Now, he may have to tell you things you don't want to hear, but that's his job. And I've never known that man not to do his job. Were you? Didn't even make any sense.
Your Honor, my position is that if she has these concerns about me and my abilities, then we're not going to move forward well together.
Hey, Mr. Ellman, I'm not going to make you stay with somebody that can't appreciate your talents. I'm just not going to do it. I mean, that's going to be her business. Were you appointed on this case?
Yes, I was, Your Honor.
That means the PD had a conflict.
That's correct.
Which means it's got to go back, which means that I'm going to put this over. And for the time being, ma'am, guess what? You don't have an attorney because I'm letting you withdraw. And they're going to have to get me an attorney and you'll be notified as to who they are. So make sure you answer your phone.
This is one of those moments where courtroom decisions have real-world consequences instantly. The defendant thought replacing her attorney might improve her situation, but Judge Simpson is making it crystal clear that this move comes with collateral damage. Once appointed counsel withdraws because of a breakdown in communication, the entire process slows down. New counsel has to be assigned, schedules shift, and momentum disappears. What's fascinating here is the judge's tone. He's not yelling, he's not threatening, but the sarcasm in "guess what" says everything. He's basically warning her that distrust in the attorney-client relationship can backfire hard. And notice another key legal point. Because the public defender's office already had a conflict, this case has to cycle back through the appointment system again. That is not a simple administrative inconvenience. That means more delays, more uncertainty, and potentially more time under court supervision. Also, pay attention to how Judge Simpson handles Attorney Ellman. He refuses to force the lawyer to stay on the case. That's actually important legally and ethically. Courts generally cannot force a broken attorney-client relationship to continue if communication has collapsed beyond repair. Question for you watching this case unfold. Do you think the defendant genuinely believed her attorney failed her? Or do you think this was frustration boiling over at the worst possible time?
Probable cause conference will be adjourned. You are discharged from any further obligation.
Thank you, Your Honor.
Mr. Hellman. Probable cause will be adjourned to November 25th, 2025, 9 a.m. Bond will continue. Thank you.
Your Honor, that's it for me today, Your Honor, and thank you for those kind words.
Yep. Another happy customer. I didn't say anything. I don't know why you start crying. I said nothing.
Your Honor, while we're waiting a second, I believe defense counsel is going to approach with a plea form and an advice of rights, in which case I'm going to have to make a quick amendment to it because the plea form? Yes.
Well, and that's fine. And I'm just going to tell you, we've got a problem.
We know what the problem is, Judge. So we'll address it, Your Honor. Yes. Oh, thank you.
Okay. So that's the plea, but I'd like to address the bond issue first.
Okay. I know what it is. I've discussed it with my client, Judge. So
now the courtroom takes a sharp turn into something even more serious, a bond violation involving cocaine while already facing a cocaine-related charge. And from the second this conversation starts, you can feel everybody in the courtroom already knows the problem before it's even fully explained. The defense attorney is doing everything possible here to soften the landing. He brings up the cancer diagnosis, outpatient treatment, medical issues, prescriptions, upcoming appointments, basically presenting the court with a picture of someone struggling physically and emotionally instead of someone simply ignoring conditions of release. That's not random sympathy building either. In bond hearings, context matters enormously. But here's the problem the defense cannot escape. The court's trust has already been damaged. Judges take drug testing conditions extremely seriously, especially when the underlying criminal charge involves the exact same substance showing up in testing later. From the court's perspective, this starts looking less like a mistake and more like a pattern. And the attorney's wording is telling too. Listen carefully. He admits she hasn't given him a whole lot to work with. That is lawyer language for, I'm trying my best here, but these facts are bad. At this point, the entire hearing becomes a question of credibility. Can the defendant convince the court she's capable of following rules outside custody, or has that window already closed?
I know.
Somebody want to explain? I've got a positive test for cocaine.
That's correct, Your Honor. Judge, there's not really an explanation per se, Judge. I just would indicate to the court, she's dealing with a lot of health issues right now, Judge. I think, again, she's prescribed the opiates. I know that's referenced in there, but she's got a cancer diagnosis, Your Honor, and I think that's she has a appointment tomorrow, Judge, and she is enrolled in outpatient treatment, Judge. So I'm just gonna, if we're gonna take the plea today, Your Honor, I'm just gonna ask the court to maybe refer for a pre-sentence report, let her meet her requirements, and then we'll see. We can deal with all these issues at sentencing. I'm going to propose that anyway.
There's options. I would note that the case is from back in early 2024, March of 2024, and the charged offense of possession of cocaine is the same controlled substance that the defendant is currently using, and that's concerning.
I thought we had. I want to make sure. I thought there was a previous violation.
There was, Your Honor, I believe it was for missed tests and not positive tests, but that's correct.
So she admits to the violation?
Yes, Your Honor. She did not have, other than, I mean, obviously they listed opiates. That's not, I don't think the court's concerned about that part, but.
I'm not concerned about the opiate part because at least there's an explanation that some of the.
I've discussed it with her, Your Honor. Obviously, she's indicated a lot of pain, and I said that would address the opiates, probably not the cocaine. But she understands that, Judge. But again, she's enrolled in outpatient, Your Honor. Her next appointment is Monday. She just got out of jail after being in there about 10 days, Your Honor. And I understand, and I've told her this could put her right back into jail.
This is where the emotional side of the courtroom collides headfirst with the legal side. The defense attorney is practically pleading for one more opportunity: outpatient treatment, medical care, oncology appointments, rehabilitation. He's laying out every possible reason the court should show patience. But Judge Simpson is focused on something completely different: reliability. And honestly, from the judge's perspective, the logic is brutally straightforward. The defendant was already given a chance. She allegedly missed tests, then tested positive after bond reinstatement, all while knowing jail time was hanging over her head. That combination is exactly what causes judges to lose confidence fast. One thing viewers often misunderstand about bond violations is that courts are not only punishing bad behavior, they're evaluating future risk. The judge is asking himself, if the defendant could not follow conditions while freedom was already on the line, why should I believe the next promise? The attorney also makes an unusually candid statement here by openly admitting the situation could send her right back into jail. That honesty can sometimes help credibility with the court because it shows counsel isn't pretending the violation is minor. But emotionally, you can feel the desperation building. The defense is trying to humanize her circumstances before the judge fully shifts into enforcement mode, because once that happens, mercy becomes much harder to obtain.
So she hasn't given me a whole lot to work with, Judge. I'm just asking the court to consider allowing her to come back for sentencing and, let her do the outpatient and let her go to the oncologist tomorrow. Sorry.
And Mr. Burgess, I certainly understand that. The biggest problem that I have here, though, is that she was missing tests. She's here on a cocaine charge. She takes a test and cocaine's coming up. And
Judge, she knows she's facing, if the court accepts the plea today, she knows she's facing up to a year in the county, obviously, for the charge. So if she comes back with more tests, obviously that's more time. She knows the judge. So.
I'll hold on to the plea form, Mr. Reynolds. And we'll take her plea next week, and I'll make sure that at the time of taking her plea, she's clean, because I can't even guarantee right now she's clean. So I'm going to adjourn the probable pardon.
I have a serious appointment with my pastor. I just found out the other day. I have an appointment tomorrow to see my specialist. It's a mass tumor. They're trying to see what they're going to do with it, if it's benign or it's full-blown cancer. I promise you, for please today, I will not have no more dirties. I will not miss an appointment. I will not do anything. I will be.
Ma'am, you get picked up, arrested on a charge which involves the use of cocaine or possession of cocaine. You come here before me, we put you on testing. You don't do your testing initially.
I forget.
Then once we get you, I reinstated your bond previously. You get out, and what do? You test dirty. I can't trust you. Defendant's bond is revoked. Defendant's remanded. I'll return this matter to the 13th, 9 a.m.
Please, I can't. Please, God. Please. I promise you I won't give up. No more dirty, ever.
Yeah.
I will do everything you want. Please. Please, Your Honor.
This right here is the exact moment the courtroom stops feeling procedural and starts feeling devastating. The defendant is begging, crying, promising she'll never miss another test, never produce another dirty screen, never violate conditions again. But the judge has already crossed the line from warning mode into consequence mode. And the reason this hits so hard emotionally is because you can hear two completely different conversations happening at once. The defendant is talking about fear, illness, and survival. Judge Simpson is talking about trust, accountability, and repeated violations. Those two perspectives are no longer meeting in the middle. Legally, bond revocation is massive. Once the judge says, "I can't trust you," the entire framework changes. Bond is fundamentally built on the idea that a defendant will follow court orders while remaining free pending proceedings. Once that confidence disappears, detention becomes far more likely. What makes this scene especially gripping is that the defendant keeps trying to negotiate emotionally after the decision is effectively made. But judges often become even firmer once they believe manipulation, excuses, or repeated promises have replaced compliance. And viewers, be honest. Do you think Judge Simpson made the correct decision here based on the repeated failed tests and violations, or should the medical circumstances have outweighed the violations?
You said a week, Your Honor? 13th.
Thank you, Your Honor.
Stephanie Cannon on behalf of Ms. Law. Ms. Law, could you please state your name for the record?
Sandra Law.
Let's go ahead.
Just I lost her.
You did.
I lost my intern, Your Honor. I'm sorry.
All right. What are we doing on Ms. Law's case?
Well, Your Honor, we are working on the case. She does have a bond violation. The court is well aware of it. We did receive, and I did provide the prosecutor.
Counsel approach.
Yeah, you're right back.
We're back on the record in the law matter.
Yes, Your Honor.
What I'm going to do is, we've had a bench conference in this case. I'm going to adjourn this out 1 week to November 13th, 2025 at 9 a.m. However, on September 25th, she tested positive for cocaine or other drugs, but my understanding is type medication. That's on September 25th. October 1st, she then tests positive for alcohol. So I have those two consecutive tests, or those two tests where she's got something in her system she's not supposed to have. And then I don't have another test from her.
Yes, Your Honor. I do understand that, and I will be providing the court with some medical records indicating that for a very good chunk of this, she was actually hospitalized. But my view of it, in truth and candor, is not indicated for all of it, but for a very good chunk of it, she was hospitalized. And Your Honor, I will do an order for inpatient treatment to see if that'll work for this court.
It may, but at this time, given what I'm seeing, I just put it over 1 week. You can get that information to me, but at this time, defendant's bond is revoked and it's remanded.
Thank you, Your Honor.
By the end of this courtroom sequence, the pattern becomes impossible to ignore. Repeated bond concerns, repeated substance-related issues, and a judge who increasingly prioritizes public trust and courtroom compliance over verbal assurances. In this final exchange, the defense again attempts to introduce medical explanations and hospitalization records in hopes of slowing down the consequences, but Judge Simpson is clearly unconvinced without stronger proof and consistent compliance. What stands out most across this entire case is how Judge Simpson handled credibility. Whether it was the defendant criticizing her attorney, repeated testing violations, or explanations tied to medical hardship, the judge repeatedly returned to one central issue: accountability. In his view, promises alone were no longer enough. There were also two very different courtroom philosophies on display. The defense emphasized rehabilitation, treatment, and compassion. Judge Simpson emphasized structure, trust, and consequences. And once the court concluded the defendant was not reliably following conditions, the rulings became dramatically harsher. From a legal perspective,
the judge's rulings followed a very clear logic chain.
attorney withdrawal approved due to breakdown in communication. Repeated violations considered serious because they mirrored the underlying offense, and bond ultimately revoked after the court lost confidence in future compliance. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.